It is March 25th, 2026, and this is the Court Gallery. Welcome, ladies and gentlemen. What happens when a defendant with a crap ton of dope thinks a plea deal for probation is a sure thing? He didn't count on Judge Mogan, who sees right through his prepared speech and a jaw-dropping sentencing you have got to see to believe. Then, the road rage suspect argues his way into even more trouble, and a series of defendants with flimsy excuses learn a hard lesson about accountability from Judge DeSantis. Get ready, because the gavels are coming down hard today, ladies and gentlemen. Grab a drink, get some popcorn, and buckle up, because it all starts right now.
In the matter 25 CF 98, State of Wisconsin versus Brandon Allen. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Filiski, Defense Counsel, in person. Mr. Allen appears in person in custody. We're set today in this matter for a sentencing hearing. Mr. Allen pled guilty to one count of possession with intent amphetamine, methamphetamine, greater than 10 grams, but less than 50 grams, a Class D felony. He did so on January 9th, 2026. The court ordered a pre-sentence investigation report, and the court has received that report. I have reviewed the report, and now I'm quickly going over to see if I noticed anything myself that jumped out at me as a material mistake that would need correction. The court did not note anything of concern. I believe we are dealing with 43 grams of methamphetamine. I'm not sure if that's is that the lab?
Yes, it's 43.07 grams.
3.07 grams of methamphetamine. I have received and reviewed the pre-sentence investigation report. I have late received the sentencing memorandum from Mr. Allen, but I have reviewed that as well. I do not believe that there was anything else for the court to review. I don't have anything off the top of my head about any character references or anything of that nature.
Your Honor, I did reach out to Cliff Cassidy and Mark Peterson for letters of support. They have a prior relationship with Mr. Allen. However, as of this time, they've not provided me with letters of support to that effect.
Is anyone making any statements here today?
I had asked Mr. Allen's supporters here if they wish to make any statements. They indicated they did not wish to speak.
All right, thank you. Mr. Vila, then I'm going to turn to you for your sentencing recommendation and argument, please. And before we begin, I believe that something was discussed between counsel, and then it was stated off the record by Mr. Filiski that there would be a now joint recommendation, even though the state is capped at the PSI recommendation. It's now going to be a joint recommendation argument to the court.
That is my understanding. I'll defer to defense, obviously, on that.
Certainly. To elaborate on that, Your Honor, after review of the pre-sentence investigation, its contents, as well as the recommendation made, and discussing this case with Mr. Allen, he indicated that he was frankly quite comfortable with the recommendation by the PSI. We had an agreement, as the court noted, for the parties free to argue with the state capped at the recommendation of the PSI. But given the circumstances here, I believe a joint recommendation under the circumstances would be appropriate.
All right. Okay. Thank you.
Thank you. So Just to briefly remind the court how we got here, this was a situation where officers made contact with Mr. Brandon Allen at a gas station. There was a suspicious issue regarding the motorbike that he was on with the license plate not matching the motorbike. He had a black bag in his possession, tried to dispose of the black bag. When law enforcement finally recovered it, they found the 43 grams of meth inside. So the DOC here recommends 5 to 6 years in the Wisconsin State prison system, broken down as 3 years of initial confinement, followed by up to 3 years of extended supervision, stayed and imposed in favor of 5 years probation. That's what the state's arguing for, and apparently that's the joint recommendation. So 3 years of initial confinement, 3 years of extended supervision, imposed and stayed in favor of 5 years probation. The goal of this sentence should center on rehabilitation and deterrence. Going through the PSI, it's quite apparent that Mr. Allen has no substantial criminal history really of any kind. He has a couple low-level theft cases on his record. He completed a 7-month supervision term related to one of the thefts that took place in 2003. The case at hand here today is obviously a very large step up in exposure in the criminal justice system. With that in mind, I believe the court needs to address Mr. Allen's substance abuse issues while also taking into account the gravity of the offense and the need to protect the community as a whole. As the PSI correctly points out, 43 grams is a significant amount of meth.
Big ton.
It's a big amount of meth. So the court needs to therefore impose this sentence that provides Mr. Allen with the opportunity for programming, but on the other hand, hefty enough of a punishment to properly reflect said seriousness of said offense and the need to protect the general public. The carrot or the stick metaphor, so to speak. Ultimately, that's what the state's arguing for is 3 years of initial confinement, 3 years of extended supervision, imposed in the state of 5 years probation. Thank you.
Thank you. I'm going to need a hefty argument as to why I should follow the recommendation. This is an S ton. It's a lot of ton of methamphetamine, a lot of ton that this is an intent to deliver, a manufacturing and delivering 43 grams of meth. And that was not denied. This is a lot of ton of meth. A lot of meth.
Thank you, Your Honor. I'd first like to address the issue of credit. Mr. Allen was brought into custody on this offense July 10th of 2025. He was then released on bond on October 29th of 2025. He then was brought back into custody on this matter on December 4th of 2025 and has remained in custody thus since. By my math, I have 223 days of custody credit. As was noted by the parties, Your Honor, this originally wasn't a joint recommendation. We were going to be free to argue. I communicated that as much to Mr. Allen that we could argue for time served. We could argue for a lesser sentence. We could argue for a lesser sentence with probation. We were free to argue whatever sentence we would like. In review of the PSI, what struck me about Mr. Allen's response was how much he was willing to accept it. As the court noted, this is a substantial and extremely serious matter. This is a substantial amount of illicit controlled substances that were located on Mr. Allen. There is a reason that this is a Class D felony. There's a reason that the maximum penalty for this type of offense is so high. As the court has often noted, methamphetamine is a plague on this community. It's a plague on this country as a whole. I'd go even as far as to say that it is a plague on society writ large, no matter where you go. It ruins lives. It destroys people. It breaks apart families. It is fundamentally incompatible with a peaceful, polite, law-abiding society. Mr. Allen has spent 223 days, every second, every hour, every moment, sun up to sundown, thinking over his accountability, his responsibility to society, to this community, for the commission of that offense. And in reflecting on that, Your Honor, I think he understands first and foremost that this needs to be the end. This never should have gotten to this point, but this case, this matter, this needs to end here and now, because if it does not, Mr. Allen knows that his life is on the line, his family's life is on the line, his children's life is on the line in his absence, in the ways that his actions impact and affect them directly and indirectly. This needs to be the end. And it's out of consideration for that. It's out of consideration for his need to address the substance use issue, which I believe, Your Honor, is at the heart of this matter, of Mr. Allen's past criminal history. It's the need to address the coincidental mental health issues relating to grief and trauma. These are the reasons for why we are going with the joint recommendation for an imposed and stayed sentence with probation. Because Mr. Allen understands that he needs to be held accountable. He needs supervision. He needs someone looking over, making sure that he is doing what he needs to do, what he has to do in order to reintegrate into society. He understands the gravity of that. He understands that, frankly, this PSI is a gift. It is unusual for it to make a recommendation in this manner. I think in large part why it does is that it identifies what the core issue fundamentally here is, which is, again, I would say a coincidental mental health and substance use issue. As the PSI and as the sentencing memorandum noted, Your Honor, this all seems to have started when Mr. Allen lost his brother in the line of duty. His older brother, my understanding, served in Iraq and tragically lost his life there. From that point, from what I can tell in my conversations with Mr. Allen in review of the PSI, it seems that a cycle began to emerge. He took substances to grapple with the pain, the grief, the anger, the trauma. He realized that he had a substance problem. He addressed it, moved on with his life, and then encountered another crisis. Once again, he relapsed, went back to methamphetamine, realized it was a problem, addressed it, moved on. Same thing happened. Crisis, relapse, readdressing, moving on. The point I'm making here, Your Honor, is that I think the PSI in part characterizes Mr. Allen as not taking this seriously. And I think under the circumstances, I can understand where that perspective is coming from. But what I would clarify on this is that he's not minimizing this. He's recontextualizing it. He understands that this is not simply an issue of I use meth and I need to stop using meth. It's an issue of I'm using meth because there's something inside of me that's broken that I don't know how to deal with. And he's kept coming back and back through that cycle again and again because of that underlying issue. In the time that he's had, Your Honor, to sit and think about what got him to this point and what he needs to do and what has to happen going forward, he realizes that it's both. It's addressing the substances. It's addressing the substance use. It's addressing the environment that he's in regards to the people that he's around and the relationships that he builds. But it's also about understanding why it is that he ends up there. It's about understanding what he needs to do to avoid getting there. An ounce of prevention, Your Honor, is well worth a pound of cure. I think Mr. Allen understands that. And I think, again, in light of that, that is why he does wish to have a joint recommendation here and accept probation along with this very, very hefty sentence. In the course of my representation of him, Your Honor, I believe Mr. Allen is at his best when he's helping others, when he's out in the community, when he's developing positive relationships, when he's around positive people. I think that's when he shines. I think that is the key here that will unlock a very bright future for him. I think he's driven and ready to succeed. I think he demonstrated that by being the first inmate to graduate here at Burnett County Jail in the HSCD program. I think he demonstrated that, as was indicated in my sentencing memo, with his intent to get health care and follow up with employment programming. One additional thing that I did note, Your Honor, and that has been noted by this court before, is the issue of association. When imposing a sentence, it's critical to assess how long or how short that can be and what the ramifications of that decision can be. Too short of a sentence, they're not learning their lesson. They don't understand the gravity and weight of what they did. Here, my concern would be that if Mr. Allen were to immediately enter into a substantial length of custody, that would do unintentionally would lead to him creating bad relationships with bad people. It would put him in an environment without supports that he needs from positive people in the community that are going to keep him out of this type of behavior. With all that having been said, Your Honor, I think looking at the Galleon factors here, that the recommendation by the parties with the PSI is appropriate. The recommendation for an imposed and state sentence of 3 years of initial confinement and 3 years of extended supervision is a substantial amount of time hanging over Mr. Allen's head. He knew that it could have been a far higher amount by entering his plea to begin with. He's here today to take accountability and responsibility for what happened and understanding that he needs this incentive, this stick, so to speak, to keep him accountable. In protecting the community, recommendation here for 5 years of supervision through the department. That's a substantial period. That's a very, very long time for him to be on his absolute best behavior, because he is well aware and knows if he doesn't do well on probation, if he doesn't do what he needs to do to address this underlying problem, he's going to have no choice but to have to address that problem in a confined setting in custody. I think here the recommendation for an imposed and state sentence with probation is appropriate stick and carrot. Additionally, Your Honor, Mr. Allen will have access to programming through probation that will allow him to address this underlying issue and keep him involved and invested in the community. Again, if he's not able to do this on his own, this recommendation will ensure that he must address it by being revoked and sent back into the prison system. In regards to Mr. Allen's rehabilitative needs, Your Honor, I think again, the PSI statements by the state and by the defense here make clear that this is at its heart a substance use issue. Mr. Allen knows this, he acknowledges it, and he's doing everything that he can in his position thus far to address it, and will be doing everything he can once he is out of custody going forward, whether that happens today, tomorrow, a year from now. In my conversations with him, Your Honor, I picked up on a few things. The most important detail is one that to me is very indicative in my line of work about whether I'm going to see someone again or not in this role. And that's that he acknowledged that he has a problem. He's not trying to duck responsibility, Your Honor. He's not trying to avoid taking accountability here. He's agreeing to a substantial amount of probation, and he's agreeing that if he doesn't meet those terms and conditions, if he doesn't do well, if he's not on his very best behavior with the department, that there is going to be a punishment for it. Put differently, Your Honor, I'm in a line of work where a lot of people want to avoid trouble. They want to avoid a certain outcome. They want to avoid accountability. They don't want to go to prison. They don't want to go to jail. They don't want to do probation. They don't want to pay a fine. They don't want to do programming. They don't want to do anything that someone is going to make them do. That's not the case with Mr. Allen. Mr. Allen knows that there's a problem here and that he knows he needs to address it. He knows that if he doesn't address it, it's not going to go well for him. It's not going to go well for him here. It's not going to go well for him going forward. He is extraordinarily blessed to have a loving and supporting family through his mother, through his children who have been with him, who have stood by him, who have said, despite this, we know your heart. We know your character. We know this isn't you, and we understand that you need to take accountability on this, but we're here for you. I think that was when Mr. Allen is released from custody, I have full confidence in his ability to succeed. It would cause me a great deal of pain if he were not to do well. I don't mention that often because, frankly, I don't like to get personally involved in these sorts of matters, but Mr. Allen has struck me. He struck me as someone who made incredibly poor decisions and ended up in a situation where his very life was on the line, and still is. He's handled that with grace, with candor, and he's ready to put his best foot forward, Your Honor. I think the agreement here reached by the parties is appropriate. I think it addresses the galleon factors here sufficiently, and I would ask this court to follow the agreement. Thank you.
Thank you. Mr. Allen, this is now going to be your opportunity to tell me anything that you think I should know, anything you think I should consider, things that you think may need to be corrected or need to be stated in more detail or depth. You also need to tell me, because I'm interested in knowing whether or not you have any treatment lined up, whether or not you have a plan for the future, what it is that you're thinking. And if you're reading a statement, I need you to read it slowly. I need you to enunciate your words. My court reporter needs to be able to take everything down, and I need to hear you.
I'll try my best. I'm kind of.
If it's
Super
emotional,
nervous.
take your time, stop, take some breaths, then continue.
Well, okay, I wrote this a little while back. When asked about my true feelings about this incident, I don't feel as though I've been able to fully express myself or to be interpreted as I see fit. I feel writing my true thoughts under stress is the best way. So here goes. I hate drugs. I despise crime, and I cannot stand criminal behavior, which leads me to the feelings of constant regrets, depression, and full hypocrisy, feelings that I struggle with daily. I follow all the laws to the best of my abilities, which have gained me my best reputation and rapport with those that I have in my life. Knowing what pleading guilty would fully do to my life, my reputation, my credibility, all that I've worked my whole life for, I still chose to be 100% honest and accountable for this crime. Not for sympathy or any other angles, but because it's the right thing to do. I committed this crime, and I don't believe in wasting anyone's time by taking it to trial or attempts to downplay it, because that's who I am and who I will always be. A 100% honest and genuine person struggling with my own demons. It's hard for me to express in words the full effect that my time in jail has taught me, or the way it's redefined my moral compass, because it is something that's in my every thought, every second of every day. Webster's dictionary defines the word accountable as follows, as an adjective, being the one who must meet an obligation or suffer the consequences for failing to do so. I feel as though the past 8 months I have paid for this many times, with many seconds spent regretting my actions, as well as feeling the sting from my guilt and remorse with those I've hurt and have had to suffer with me being in here. Guilt, remorse, the feelings of responsibility for wrongdoing, regret, self-reproach, shame, and penitence are all feelings that come to my mind at a regular basis while waiting for my sentencing. The world did not stop spinning since my arrest and has created a world for me to face at a different level upon my release, which I am learning to do so daily. My reasoning for drug use has been nothing short of an excuse to mask my true feelings over grief and loss, which from learning from fellow inmates in here, I am fully capable of overcoming given my new outlook on my life. Taking it upon myself, I have developed my own personal program for handling my feelings geared towards overcoming the feelings, which I've spent the majority of my life masking. Preventative mentality is all I have to offer to prove this cannot happen again. All stemming from what I believe to be the most important question of all, not asked during my PSI, was what I have learned while being in jail. I've learned more in 8 months than I have from any treatment program, learned from observing and empathy. I can honestly say with all my heart that I do not belong in any facet of life other than being a loving and present father, son, and a man who sets examples to follow and strives for success in all things. You asked me if I had any plans for once I am released. I know that there's a couple of places in town here that are offering like Aurora, I believe it is, for help getting my Badger care up and running, which would also help me with my education. Ultimately, outpatient treatment is something that I would be seeking. I'm not quite sure if it'd be through Superior or if there's any more places local. I spoke with a lady a little while back about psychotherapy, possibilities of looking into that. Work, I got an application all set to go today to the bar / restaurant that I worked at, but not as a bartender. It would be in the kitchen. Basically trying to do my best to slowly plan it out so I don't bite off more than I can chew, but at the same time, keeping myself and holding myself accountable so I don't put myself in a position that is gonna basically start everything all over again. While in here, I started that by basically blocking and deleting my entire friends list on SIDNet with the exception for my mother and good friend Jennifer behind me. I believe that that was the start of it. I believe that if I'm not in a setting or if I'm not around people that are using, I'm 100% confident that I will succeed in this. Mr. Flisky did say that one of the happiest, when I'm most happy is when I'm helping others. I even came up with a program that I thought would benefit felons or addicts. But in doing so, I realized that maybe I should hold off in helping addicts until I'm able to help myself.
Yep, that's a big one.
So, I mean, I want to help everybody. I always do. I mean, my mother will tell you that. But yeah, that couldn't be more real to me right now. I'm not ready to help people. I am ready to help myself though. Thank you.
Thank you. There is no ifs, ands, or buts about it at all, not one bit, that this is a very serious matter, extremely serious. No question there. 43.07 grams of methamphetamine, weighted grams of methamphetamine. That is an S ton, and I'm just not swearing here. That is an S ton amount of meth. 3 grams is intent. You can get charges for intent and deliver, for selling, for dealing. 3 grams. You had 43 grams of methamphetamine. That is not a little bit of meth. That's a lot of methamphetamine. A lot of methamphetamine. So very serious, out of the gates. I was extremely jaw dropped when I read this pre-sentence investigation report. My jaw dropped when I read the recommendation. Gonna be honest, I'm gonna be blunt, I always am. Mr. Allen, you are a likable person. I like you. I truly do like you as a person. Me liking you and me doing my job and what is right in my job are two different things. I like you. I respect the fact that you worked extremely hard to get your GED. So proud of you. I cannot tell you how much that means to you, to your family, and it means something to me. You did that. You didn't have to do that. You could have sat in jail and you could have just sat and twiddled your thumbs and wanted the time to go by, but you took advantage of the time you had in custody and you got your GED and you helped others doing that. You helped others succeed and accomplish that too. So there are many things about you that I like, I respect. I think you are a good person. I see you have a good heart. I've seen your family come and support you. I've seen your daughter thrilled when you got your GED. I've seen those things. Those things make you human to me. I try and have everyone that's seated in that seat right there be a human to me and not be black and white paper. Because black and white paper, then you're simply looking at all of the bad and not allowing to see the good. I see the things and I understand to the best of my ability with my personal experience, my professional experience, and all that I've gathered in my many, many, many years on earth, that there's more to a person than the black and white. All right. And you have to take all of that into account. And for me to do my job and to do my job well, I need to see you as a human, as a person who has faults, who has issues, who has the good, the bad, and the very ugly. And that comes into account in all of my sentencing. So I see you. And I hear your words. To me, I'm going to tell you, and again, I'm going to be blunt. I liked them. They're good. They came across. They had a good, that was a good topic, good foundation, good things to back it up. It seemed like you were giving me a speech. The dictionary defines, this is what it says. It seems like you were trying to sell it to me that you do understand, or that you get it and this is what it is, and like you're trying to sell it to me that you're telling me what I want to hear or what I should hear in order to follow the recommendation, because that's where we should go and let's go on probation. I've heard more heart from you at your GED graduation speech than I heard in that. And that was supposed to be a speech. This is supposed to be a, hey, judge, this is where it is and this is what's happening. It's not supposed to educate me on what the dictionary defines something as, or what I should see, or how I should see it, and where it should fall into play. This is where you are essentially begging for your life. And you should be telling me all of the things that you've already planned. I've already talked to Teen Challenge. I've already talked to, Betty Ford. I've already talked to the place in Florida. I've already talked to the place in Texas. I've already done these things. I've already arranged and set up a treatment, an inpatient treatment facility with a bed, and it's lined up if I'm able to go. And that is at the mercy of the court, and court, please see this, and I've set it all up and this is what I've done. I don't hear that. I see individuals who have substance abuse issues every day. But I'm going to tell you and be honest, I don't see them sitting in that chair, people with substance abuse issues in the chair like you are today. 43 grams of methamphetamine. You do not have an extensive criminal history. I think there was like two thefts or something of that nature. Nothing big. I don't know if that's because you haven't been caught at doing things. I don't know if you really do follow the law and you just slipped. I understand pain. I understand loss. I understand death. I understand feeling like you want to give up. I've been there. I've had loss too. I don't turn, nor has many other people seated in that chair with substance abuse issues turned to 43 grams of methamphetamine and intent to deliver and that devastation and destruction. They turn to self-medicate and they self-medicate and they have and they do, but not all of them sit in that chair with the heaviness that you have on your shoulders today, that you placed on your shoulders today. And you were given a chance on bail with certain conditions. You violated those conditions. Wham, bam, straight right back to using methamphetamine. And I think, didn't you say your cat died? That's why. And that was the reason, that was the excuse. And it's a poor excuse, your cat died. And so you went back to methamphetamine. Instead of reaching out to somebody else, instead of trying to go to your mother, instead of looking for a meeting or any other thing, your cat died. And so you're like, blah, I'm giving up now. I'm going to use again. When you knew you had so much on your shoulders at that time, so much to risk and to lose, $2,500 in cash that I believe your mother put up, that the court had every legal right to forfeit and to say bye-bye to that money. But I didn't, because I knew that that would actually hurt your mother. I get it. Pets are like children. I had my pug for 17 years. I lost her. It's hard. You reach out to other people. And at that time, at that particular time, you had also told the court you have learned all of these things that you recited in your letter. And I get there are relapses. I do the treatment court. I get those types of things. But not everybody has the weight on their shoulders that you do. 43 grams of methamphetamine. Mr. Filiski made a good statement in his argument. He has went to the depths of his soul to argue for you here today, because he knows how serious this is. And he made a really good statement about your associates. I believe that his association and who you associate with. He's very correct. And I have heard you say that you've changed, you've deleted all the people out of your phone and out of your contacts and all of those kinds of things. You haven't been out of custody long enough with this over your head to have those kinds of things fully sink in yet, because you've been in custody. It's so much easier to maintain your sobriety, to have the positive outlook, to do those kinds of things while you're in custody. But once you are out of custody, you don't have that confinement. You have forced sobriety right now. And you don't have that confinement to ensure that you're not going to use. And again, that's why the treatment is important, or a treatment aspect is important. And it shouldn't be upon me to tell you to look at those things or to get a plan or to have something in place just in case, or if the court were to go along with probation. It's not on your attorney, but you know, that could be a way to try and have the court follow a probation recommendation. It's on you. You're the one who is changing you. You're the one who has to look at making your life better and doing better and showing me that you're not going to be a threat to my community, that you're not going to be a devastation of destruction to this county or to any other person. And all I've heard is, well, maybe there's Aurora, maybe there's some other outpatient things in this county, maybe there's things. I don't think you've went through that process of admitting to yourself that this is real and this is really serious and you are fighting for your life. And I stressed to you, as I stress to everybody that I take a plea with, especially a plea of a serious nature like this, that you understand, I'm not bound by anything. I'm not bound by this recommendation. I'm not bound by the state's argument. I'm not bound by Mr. Filiski's argument. I'm not bound to listen to your plights and requests. I'm not bound. And the reason I'm not bound is because my job is to look at the community, the public, the interest as a whole. I have to look at you in the first process, in the first part of this, and am I protecting your constitutional rights? Are you getting everything that you're afforded, plus any victims that are here? But then after that, I have to look at the community, protecting the public, and those types of things. And when Mr. Filiski was saying changing the associates or your association, you have to change. And I didn't hear that in there. I heard the skirting around it or the brief touching of it, that you want to do these things, but you have to do these things. You have to change your habits, the things you do, the things that you do that are so ingrained. You have to change your associates, the people you're with, not just removing them from your phone. You have to change those. And then you have to work on changing yourself. That is the only way you're going to significantly improve your life. You can't surround yourself with people who are putting you in those types of situations. You must surround yourself with people with who are positive supports that can influence a positive change and who can help you align with good, positive goals. That's the only way you're going to change your life. Again, I have to weigh certain things, the nature and the gravity of the offense. This is very serious. I have to look at you, your character, your past criminal record, which is very slight. I have to look at other things like rehabilitation. Do you have rehabilitative prospects? Are there other things out here? Your age, your education. I have to look at your culpability. I have to look at this crime itself. And then I have to look at needing to protect the public with a crime like this. And then it comes down to other factors such as deterrence. There's specific deterrence. I need to have a punishment that not only deters you specifically from doing anything like this again or anything similar, but I have to look at general deterrence. Something that's going to generally deter others and say, you know what, why would I even engage in that? If I do, wham, bam, slam the door, okay? Because this is so serious. I have to look at deterrence, you and generally others. And in this deal, I've heard the arguments of the state, and the state is bound. They are 100% bound. They could not go into it. Mr. Vila did not go into any in-depth about anything. He's bound by this recommendation of probation. I've heard the arguments of the defense, and it was very heartfelt, very full, very solid. And I also heard your statement to the court. And I've read the criminal complaint, and I've been here throughout the entire process of this case. You have a felony bail jump that was dismissed and read in. All in all, you have these two charges that, if found guilty on both of those charges, you would have the maximum possible penalty of 31 years of incarceration. You didn't get the greatest of all, great of all deals, and I'll admit that to you. And you pled guilty to the charge, I believe, that you were charged with. You pled guilty to the intent with the possession with intent, amphetamine, methamphetamine, greater than 10, but less than 50 grams. And that was the charge that you were charged with. You got rid of a possession of drug paraphernalia and then that felony bail jump. So it's not like you got this sweet deal. You got a good deal. You did plead guilty, and that shows something. All right. You pled guilty, you accepted responsibility, and you were like, hey, I understand. I did this. It's hard to fight 43 grams of methamphetamine. It's hard to do that. And so you are taking that responsibility. And I do give you credit for that. Not everybody in that seat would do that. So that goes on the positive favor for you. But here, the dispute here today with sentencing, I have to look at, is this a prison sentence? Is this an imposed but stayed prison sentence? Is this simply a probation with a withheld sentence? And I do have the joint recommendation of all three of these entities coming together, arguing for an imposed but stayed with probation. And so I have to determine what is a correct sentence here. What is it that I need to look at? If I'm looking at probation, I have to look at certain things. If I were to place you on probation, I need to consider, if I put you on probation, there's multiple things that I have to think about, because probation is the first thing to consider. Now, would you need confinement? Do I need to confine you to control your criminal behavior, to stop you from doing criminal acts? Do you need some type of treatment, and can you get that treatment outside of a confined setting? Or does it look like the confined setting is the only way that's going to force you to have you get the treatment that you need? I have to look at, if I put you on probation, would it unduly depreciate the seriousness of the offense? Okay, those are what the things that I have to consider. If I do a sentence of confinement, it has to be the most minimum amount that's consistent with the protection of the public, looking at that, with the gravity of the offense, the seriousness of this offense, and your rehabilitative needs. And I know the facts that is alleged in that criminal complaint. I know the statements that you've made. I know that you first said that this was personal use. 43 grams is a whole lot of personal use. That's a whole lot of grams of methamphetamine. And it's hard to have people understand that the size of 43 grams compared to a regular personal use amount. Without me showing the displays that I have, but it's a lot. 43 grams is a lot of methamphetamine. That's way beyond personal use. And so if you look at that and what the intent is behind that, again, that is participating in the devastation and the destruction of our county. I don't have any history that you've done that before. I don't have a history that you've engaged in other things before. But again, I don't know if you just haven't been caught or if this was the first time. This is the first time, man, you have the worst luck ever. Because that's a lot of methamphetamine. Again, think you have a good heart and I think you are a good person. I think you've done some really stupid and dumb things. Some devastating things. And so in a case like this, I've reviewed the PSI multiple times. You started using methamphetamine when you were 15 years old. You're 39 now. Nothing has changed. What has changed? And I've heard that you've made these steps to try and change your life and get on a better path. But it's been 24 years. I haven't heard a concrete plan of you're going to engage in treatment. You've made the plan for this treatment. You've looked at this service and you've looked at these things and you're looking down this path. And with 43 grams of methamphetamine, I can't sentence probation. I can't. It would unduly depreciate the seriousness of this offense. It would send a terrible message to the community. It will not meet the deterrence factor of deterring others and you from engaging in this type of behavior. There has to be a punishment factor. This is a punishable sentence, a punishable crime. 43 grams. But I am taking all other things into account because I've said all of those positive things for you. I feel you can change. I haven't been shown again that you have made the steps to do that, and you need something to move you in that direction to do that. So this is a prison sentence. And it doesn't make me happy to do this. But I have to do my job. This could be up to 15 years of initial incarceration and 10 years of extended supervision, maximum possible penalty, 25 years. The $100,000 fine potential. What the court is going to do is I'm sentencing you to 1.5 years of incarceration with 5 years of extended supervision. Anything else would unduly depreciate the seriousness of the offense. And it's at 1.5 years of initial confinement simply because of all of the positive things I see in you, Mr. Allen. Otherwise, it would have been far more. But I cannot with this seriousness do anything less than 1.5 years of initial confinement. $518 in fines and fees. You do have more of that in bail, but child support is requesting that be allocated over to your child support as you owe a significant amount in child support. So the court is directing that the remainder go to your child support. You have to work that out with your mother. And that is for case number 11 FA 70. When you are on extended supervision, well, first I'm going to say I'm making you eligible for the substance abuse program or the challenge incarceration program. And another reason I did 1.5 years instead of just a year, because I was considering that, is because that gives you enough time to get in, get processed, and get doing that program. So apply right away. Because I have not seen, if I had seen you or heard you come in and say, I have Teen Challenge arranged right now, I have the place in Florida arranged right now, I have this place arranged right now, if it's a go from the court, that would have weighed things a little bit differently. But without that, with knowing the seriousness of the crime, I cannot. And I have to look at other options and other things, because I'm going to tell you again, I understand and I feel your pain when you lost your cat. But if that was enough to have you jump right back to using methamphetamine, I don't know what is going to help you not, without actually having the resources. And if you're going to start using again, chances are highly likely that you're going to go down this path again. And I can't have that. No use or possession of any illegal drugs, substances, or paraphernalia. Absolute sobriety. No bars, taverns, or liquor stores. This includes employment purposes unless approved by your agent. No contact with anyone with any drug-related extended supervision or probation unless approved by your agent. Absolutely zero contact with anyone who has intent to deliver or possession with intent of any type of drugs at all. Gainful employment. Testing upon reasonable or regular testing. Any programming as required by your agent. AODA assessment and follow through. Mental health and therapy evaluation and follow through. I'm ordering your DNA. You have the ability to request it be expunged through a written letter to the Department of Justice. I'm not sure this classification allows you to have it expunged, but you can request that. 223 days of jail credit. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. This is a felony. No use or possession of any firearm. No voting until your civil rights are restored. I believe that covers everything, Mr. Vila.
I believe so, Your Honor.
Mr. Felisky.
I believe that covers it, Your Honor.
All right, thank you. Mr. Allen, I truly meant everything that I said positive about you. I truly do think those things. I had to do my job.
Thank you. All right, let's go on the record in the matter of the City of Wyandotte versus Jacob Poteet, 26327.
Attorney, you're not asking Mr. Poteet. Mr. Poteet, would you please state your full name?
Jacob Louis Poteet.
All right, very good. Thank you. Today is the date scheduled for the pretrial in this matter in council.
Yes, Your Honor. At this time, Mr. Poteet is prepared to plead guilty to the charge. One count of disorderly person.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
And you heard the plea that was placed on the record, correct?
Yes, ma'am.
And
Yes, Your Honor.
and as to the charge of disorderly conduct, how do you plead?
Guilty to disorderly conduct, Your Honor.
All right, you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes, Your Honor.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court or administrative agency, correct?
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
I couldn't hear you.
Any immigration issues?
No, Your Honor.
Okay, counsel, if you can please ready your clients.
Mr. Poteet, on the date and time in question, were you in the city of Wyandotte?
Yes, Your Honor.
On that evening, did you call the police
I could not quite hear you.
Did you cause a disturbance in the city of Wyandotte?
Yes, I did.
And by a disturbance, you were urinating in a public place, correct?
I was spitting up. Yes, ma'am.
Spitting up.
I
Well,
was-
that's not,
When the officer saw you, were you urinating on a tree?
Yes.
Satisfied, Your Honor.
thank you.
That's
The
all.
court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea as charged. Are you asking for immediate sentencing, counsel?
That's correct. I was credit for time served on Mr. Poteet, been in custody the 12th of this month. He does need to get back to the care of his doctors. He's in need of dialysis treatment. Additionally, I would like to know he is on probation out of Livonia, but has no other pending matters.
Right, which is one of the reasons why this court had ordered a cash bond, as well as the fact that your client resides out of state. Mr. Poteet, you're currently on probation out of the 16th District Court in Livonia, correct?
Yep.
And
Yes,
so
ma'am.
this obviously may trigger a probation violation, correct?
I was going to contact them as soon as I'm done with this. Yes, ma'am.
Okay, well, so my next question was going to be whether or not that was already handled. Okay, here's what this court's going to do, sir. The next time you have to go to the bathroom, go into a public place, not out in a public place.
Yes, Your Honor.
All right, the court's going to order 14 days jail, credit for 14 days. I'm going to waive your fines and costs, handle your probation issue, and then head back to Texas, sir.
Thank you, Your Honor.
Thank you, Judge.
Have a good day. All right, so we are going to go on the record in the matter of the State of Michigan versus Lewis Mazgai, 251620.
Morning, Your Honor, John Goldpaw, P 30758 on behalf of Mr. Mascai. Mr. Mascai, please put your name on the record. Louis Mascai.
Okay, is there a reason, sir, why you're dressed as though you're just going to the gym?
No, man, this is the attire I have. I don't have no dress clothes on.
Well, sir, there's ways that you can still appear appropriate and even grab something from the thrift store or something. I'm not sure. But why do you have your child here with you, sir? Is that your child that's with you? Isn't there a little girl that's with you, or a little?
Yes, my daughter.
Right. Why do you have her here in court?
That's my wife came with me today, ma'am.
Okay. Well, I'm going to have your daughter stay outside. It's inappropriate for her to be inside here. How old is your daughter?
4.
4. Right. That's not appropriate for your daughter to be here. Ma'am, if you can take your child outside, please. All right, today's the date scheduled for sentencing in this matter on your client's plea to guilty to, or no contest to aggravated assault. The assault and battery was dismissed by way of resolution between counsel. We have Mr. Cunningham present, and then we also have another individual, Ms. Hagerman, present as well on screen. Mr. Cunningham's in person. Ms. Hagerman is here on the screen. There was another individual named Ms. Hillier, but I don't believe that she's been present or that she's present. Counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, we have, Your Honor. As to the recommendation, we did have an opportunity to go over that. As to his employment, Your Honor, as is indicated here, Mr. Mascai is presently earning on unemployment. The reason being is that he works landscaping and he is not scheduled to return to the landscaping job until the end of April. Seasonal, that's when they pick up. Other than that, Your Honor, also he is still helping, working out, but I won't say under the table because he's a barber. He doesn't work as a barber anymore, but he does pick up extra by doing family members, etc. Other than that, Your Honor, there are no additions, deletions, or corrections to be made. I do read this, going over the documents that were attached regarding request for restitution. Mr. Cunningham, I'm sorry, documents that were presented appear to be, I'm just making part of this, something from the hospital or from an insurance company. I don't know if this was out-of-pocket expenses to the victim in this particular matter. But I've also spoken to Mr. Nasguy and realized that he had no intention to harm Mr. Cunningham. This was a reaction, and that when he pushed him, he had no intention of causing any injury to him, though the plea obviously was to the aggravated no contest.
Okay, excuse me one moment. Sir, what did you think would happen when you pushed an individual?
Well, ma'am, he approached me, he's screaming and cussing.
No. Before we get to that, that's because there's something before that.
No, it was a push. Like,
Stop.
get out my face.
Just one moment. Had you not pulled your vehicle over and gotten out of your vehicle, none of this would have even occurred.
Same for him.
So,
Quiet.
no, it's not the same for him. He had pulled over to go to a yard sale or wherever he was going.
Be ramming off the road, man.
Sir,
Okay, I'm just, okay.
what did you think would happen when you put your hands on someone to push them?
I don't know, man.
I don't know, it doesn't work in this court. What did you think would happen?
I was just trying to get him out of my space, man. That's it. I didn't intend on hurting him. I didn't intend on him falling. I didn't intend on none of that, man.
No, I hear that. That's why I'm asking, what did you think would happen when you pushed him?
That he was going to get out my face. That's it, man.
Okay. You may continue, counsel.
I was just indicating he realized this was the wrong thing. And of course, the wrong thing was to even stop there. I agree with that. And he understands that now. At the time, he clearly didn't and wanted to resolve what he believed.
But man,
Address, be quiet, and then you can talk with all you want.
I would never stop. My daughter hit him out the window, sir.
Okay? Then
I mean, that's all it was.
You had your daughter with you?
Yes, my daughter was in the backseat, man. I had another, I had my.
Hold on. So I just heard you say to your attorney that your daughter hit her head off the window.
Yes, she was in a car seat. She
She was in a car seat.
Yes.
If she was in a car seat, how did she hit her head on the window?
A 300 is a small compact car. Her car seat's tucked to the window. When he ran me off the road, man, I hit the curb.
Hold on, sir.
I hit the curb.
What?
Her head off the window.
Hold on. What type of car seat was your daughter in?
A full car seat, man.
A full car seat,
Yes.
right? And the full car seat has the pieces of the
Yes.
headrest that go out.
Yes.
So your daughter wouldn't be able to hit her head on the window.
I'm sorry.
On the window.
It's a booster seat, ma'am.
Well, see, now that's something different. A booster seat's different from a car seat, a full car seat.
Right.
You just said it was a full car seat.
Right, a full upright booster seat. She's 5. She's turning 5, ma'am. She's almost 5 at the end of this month, ma'am.
So she was 4
Yes.
when this happened.
Yes.
Okay. So your daughter was with you.
Yes.
The victim pulls off down a certain street.
He pulls over because they have it in front of the yard sale, ma'am. This is exactly what happened.
Well, when I read the report, it showed that he turned.
I turned off of 6th Street, ma'am. I live off of 6th and Hudson. So that's how this was happening. Picking on my daughter.
So I don't want. Stop. Please stop talking. Mr. Cunningham was going to a yard sale on Goddard Road. Mr. Cunningham was going to make a left-hand turn off of Goddard onto Lindbergh, but the red passenger car drove by quickly. That's your car, correct, sir?
Yes,
Okay. So Mr. Cunningham pulled off of Goddard Road onto Lindbergh Street and parked at the corner of Lindbergh and Goddard. So when I said you turned, you pulled over to the yard sale. Because that's where the yard sale was. As he was standing outside of his vehicle, he heard a male yelling. Then he saw, whether it was you or not, then he saw the red passenger vehicle stopped a couple houses west from where he was and you were on Goddard Road. Right?
yes.
Okay.
But I had just made a left-hand turn off of 6, and that's where the yard sale is. The
Sir?
yard sale is on a kitty.
Sir,
Okay, well, I can't speak.
my point is that Mr. Cunningham pulled off to go to the yard sale. You were on Goddard. You pulled over after Mr. Cunningham turned. You pulled over because you were angry and upset.
But he was the one cussing.
Sir, I'm talking about you.
But I wasn't
You were angry and upset. You left your daughter in the car.
with my brother. He was there.
Sir,
Ma'am, I'm being.
Then you walked to the person that you were angry with.
No, he approached me. That's the thing. That's in my report. He approached me. He came to me cussing at me. When he got to my nose to nose with me, ma'am, I just pushed him back out of my chair.
Sir,
That's all
Sir,
I did, ma'am.
you're missing the entirety of my point.
Okay, I granted, but he wasn't going to the yard sale.
The
He
entirety
was
of
driving up Goddard.
the entirety of my point is that you never should have pulled over.
Okay, ma'am, I already admitted my faults. I admitted I'm wrong. Okay, I pushed him. I didn't mean to hurt him. I didn't have no intention to hurt him. I don't know him. It was a simple mistake. Okay,
No, that's not a simple mistake. Pulling over to get out.
to check on my daughter. And that's all I was checking to see because she bumped her. And listen, this is the God's honest truth. When I got out to check on my daughter,
Sir, you live right in the area. Then you should have just turned back around and went home to check on
exactly
your
what I
daughter.
did. I didn't.
No, no.
Exactly what I did. I took her right back to her mother, man. I turned right back. That's what I put in my report. I go, that's where they come to the house.
Okay, counsel, you may continue.
I mean, you're not even giving me a chance to speak like my side. Like it's just I already admitted my faults, man.
So what I'm hearing a whole lot of excuses
Okay,
to justify your
okay.
behavior.
Since there was no contact with the vehicles, I think he could have kept going straight too, and I could have kept going straight. That's it. We both made a mistake, and he approached me, and I did the mistake about pushing him.
Great. All right, what about the lady whose house you threatened to burn down and kill?
I didn't threaten no houses to burn down. Did anything? I've been on GPS tether for 6 months, man. There ain't been no contact.
On the same day.
My son goes to school at Wilson School.
Excuse me.
I haven't been back there. I haven't been out with no.
It was the same date of the offense.
Well, they're all recorded, ma'am. They're all recorded me. Okay, anybody wants to be recorded? It was a simple mistake, ma'am. I didn't go back there.
Okay, all right.
Your Honor, and he's
Please stop.
denying that he made those statements.
Right.
All right.
It's not part
So
of the-
counsel, you may continue as to the PSI or on behalf of your client.
We've had an opportunity to review the PSI, Your Honor. We're asking that the recommendation is 24 months probation. Other conditions, which I know the court will place upon him. Appears to be a request for restitution in the amount of $34.27. As I've indicated, the only document that I received or saw was the a hospital. It's a claims submitted by Downriver PLLC to Henry Ford Wyndham Hospital. If there is restitution, clearly this is not the appropriate amount. It's being requested. Since it's not being requested by Mr. Cunningham. Other than that, Your Honor, we're asking for recommendations.
What I'm going to indicate is that even just reviewing the police report, right? Individual people that don't even know Mr. Cunningham, I don't know about Ms. Hagerman. Multiple people stated that your client rushed over to Mr. Cunningham.
I understand what the reports say, Your Honor.
All right, so I'm going to give Mr. Cunningham an opportunity to address the court as well as Ms. Hagerman.
Your Honor, as to Ms. Hagerman,
Counsel, I'm just going to find out who she is and what she has with this case. That's what I'm going to do first. Ms. Hagerman, can you please unmute and state and spell your first and last names for the record?
My name is Barbara Ann Hagerman, Barbarann,
All right. And so are you a named victim, ma'am, or are you here to observe?
I was actually in the car when all of this occurred. We were going to a yard sale down Goddard Road. There was
Hold on, ma'am. Hold on. My question was, are you a witness or are you a victim?
I'm a little bit of both because he threatened me at the yard sale, and I would like to make a request that he is to stay out of the city of Trenton where I live. I have a handicapped daughter that I cannot move around the house fast enough. She has no legs.
Ma'am, just one moment, please. Just one moment. Okay, I'll address that shortly. And so my question was because there's an individual at a property that that was alleged to have been threatened. So I was just checking to see what Ms. Hagerman's
So if you let me explain, I'll explain exactly how it happened.
Ma'am, I'm not, we're not doing that right now. That's not how this works right now.
Okay.
All right. We're here for I'm just giving you information about the procedure. We're here for sentencing. Mr. Mazguy has already pled no contest. Mr. Cunningham will have an opportunity because he is a named victim. Ma'am, are you smoking?
I'm a little upset right now. I'm sorry.
Ma'am, you are in court.
I put it
you're
out.
in court. You are in court. You do not smoke when you're in court. I'm removing you from these proceedings. Absolutely not. Is that happening? No way. Mr. Cunningham, you may step forward and you may address the court. All right. And sir, if you could please state and spell your first and last names for the record.
My name is Tracy Cunningham, Tracy Cunningham, Cunningham.
Very good. Thank you. Autumn, if in the event that Miss Hagerman zooms back in, she's not admitted in. All right, sir. And so you're the victim in this matter. And you've also submitted some restitution requests, but you do have the opportunity to address the court. And so you may proceed, sir.
I do. First of all, I'd like to thank the witnesses who were kind enough to take a picture that day. I was knocked out in the street. And I'd like to thank the detectives. I would like to thank Mr. Muhammad and the court advocate as well. And I'd like to thank Your Honor. The first time I got a chance to see you, you took the opportunity to read the case. That meant a lot to me. That during that first day, it was a minute and a half of silence that you actually took the time to read what really did happen. And I like to tell the court I'm right-handed. And the brief situation, what you heard, I was knocked out a few feet from my car, and his was part way down the road. So you already know when the police report happened. Came to me. I never swore at anyone. I'm a retired school teacher, and the language he was using on the African American that day, The only two phrases that were said to Mr. Mezcal were, I'm not a fan of the N-word. And when he went off on that gentleman, all I said, I avoided the accident from his speed. He said he was right off the road. He was speeding. I hit the brakes and avoided that turn from Goddard to Lindbergh. I avoided it. And when he passed, I assumed he had passed. So I went and parked and was headed to the art sale. It was 5 or 6 steps from my truck. So how could I have gotten his space? Because he was parked further down Goddard. He ran past, threatening them. You know, they called the police. You can blow their house up using the N-word to the next couple gentlemen that was there. And then when he came to me, all I said was, we don't need that language. I'm not a fan of the N-word. I taught in Detroit. And I said, you were flying. You need to slow down. He punched and hit me in the chest. I fell back. My wrist was broken in 2 spots. I might have extended therapy. My therapy's out. I've only had 5 weeks physical therapy. This is 7 months and I'm still in therapy. My elbow is, I'm more worried about my elbow than the wrist that was fractured. I've had more issues with my elbow. Even though the incident happened in Wyandotte, and I apologize for my gal. We've been together 17 years. Her concern that day, even though I was hurt in the hospital, was his threat of blowing if the police were involved. We have a handicapped daughter. That's why she's nervous and upset. She's a double amputee and she's on dialysis. That's what she would wear today. We can't get, she's on dialysis 3 days a week.
Your gal or her daughter?
Her daughter. Her daughter.
Okay.
She's needs constant care. So even though you had mentioned Wyandotte, her concern was that Mr. Mezcal, I mean, he took us a point to walk all the way around the block to me, to hit me and make that threat. She felt that if you can please include the city of Trenton, that's where we reside. You always mention Wyandotte in your proceedings for him not, you know, he said he's a landscaper, that he not return to Wyandotte. We reside in Trenton. If you would just include that, because she's just worried about not so much herself as that if she would be able to will. The gentleman's behavior that day is scary. To hit a 60-year-old man for no reason. I never met him, didn't know him. I didn't get in any, but I was walking to a yard sale. I didn't even know what he was going to do. I was happy I avoided his accident from speeding. And my only solace out of this, Your Honor, is, well, first of all, with the restitution. The attorney for Mr. Mezcal is incorrect. This was sent to me by my insurance company that they weren't going to pay. I can give it to you, the original. This is what they said they wouldn't pay. So that's the only thing I had to give the courts was my insurance, for whatever reason, said they were not going to pay it. And you call insurance line that was sent to my address. That was my emergency room visit that day that is not covered. I don't know if they consider it road rage or it's auto. I don't know. All I know is I had medical coverage, ma'am. I submitted it and they sent that back to me saying they weren't covering. So I don't know what else I can provide the court that was sent to me. And my own sauce, again, I'm thanking Your Honor, is the first day that you were questioning Mr. Mezcal and you were going through his record and he kind of smugly said he's never been convicted of any crime. And you called out those words. I can now say to him, you are now convicted of a crime. And when he explains that to people, he can explain that he hit an elderly gentleman for no reason in a street, knocked me out, broke my wrist in 2 spots, and I'm still in treatment. 7 months later, I'm still in treatment. So I'm going to leave everything else up to Your Honor. I've been impressed with you. You felt me sitting back there and understanding that even though I've been there, you acknowledged it. That meant so much to me and my family. And we thank you.
Okay. And thank you very much for coming in today, sir, as well, and for addressing the court as well. Other than the 3427, is there any other out-of-pocket expenses that you
As far as I know, my physical therapy's been paid.
Okay.
So It's ongoing. I have not received a bill for physical therapy.
Okay. Okay, all right. Thank you. I'm going to give that back to you as well, sir, so that you can retain that.
A copy was given to probation.
Very good. Thank you so much. Mr. Gopal, and you may have a seat, sir. That way, they can resume that. You're good. Mr. Gopal, I'm a bit confused. When did your client move to Wyandotte?
She had an address in Wyandotte.
I'm not asking about your fiance's address in Wyandotte.
I didn't have an address in Wyandotte, ma'am. My address.
You said a few moments ago.
Be quiet.
Stop interrupting me.
Oh my God.
You said a few moments ago, sir, that you were coming from 6th and Goddard because that's where you live.
That's where I picked my daughter up from him that morning. And I dropped her right back off.
I'm pretty certain you said that's where you live.
Ma'am. That's what I meant, ma'am.
Sir, your attorney has told you a number of times, don't talk when I'm talking. Because see the recording right there? That it can record one person at a time. Stop talking when I'm talking. You stated that's where you lived. You said, I live at 6th and Goddard. That is what you said. Did you not?
Yes, ma'am.
Okay. But you don't live there.
No.
All right. So tell me about your 3 warrants that you have, sir, and what you're doing to resolve those.
Well, I have a traffic warrant in Detroit, but I'm on GPS tether right now. So that's just a matter of payment issues. And right now I owe a $320 payment for no registration till Lincoln Park. And that's all it is.
Well, why haven't you paid it, sir?
Man, that's what's been going on right now. Man, I'm on a fixed income right now. I'm making $312 every $312 a week right now. $612 every 2 weeks until work starts back up.
Sir, don't you think that you would make more money seeking employment during the off season than you do on unemployment?
Yes, but I'm going back to work. I'm going back to work.
That's great. But then for 5 months, you're not working and you're receiving minimal income. So my question, sir, instead of waiting for unemployment to come and just collecting unemployment, it would seem that it would make a bit more sense for you to go get employment for even the 5 months that you're not working as opposed to collecting unemployment.
Well, that's a stipulation with unemployment. You gotta fill out applications every week. So I'm just waiting for a call, man. That's what it is. You got a job search while you're on unemployment. So
I understand that. And so you didn't get one at all. You didn't have anybody call you for an interview or otherwise. Okay.
I've only been on unemployment 4 weeks now.
Okay. So, sir, these warrants are from June of 2025. And you've only been on unemployment for 4 weeks. So why didn't you take care of those back in June?
Well, I went to jail for one of the matters, ma'am. And then I got out and I paid one to get my
Which matter was that?
for the driving on with no proof of insurance. And then the other ticket was no registration, which that's what I owe right now for Lincoln Park, which is $340.
Which is for disturbing the peace.
No, that did not dismiss.
No, it didn't, sir.
The disturbing the peace?
Sir, I'm looking at it right here. You have a conviction from September 26th of 2025 in Lincoln Park. And in fact, you have a warrant that was issued February 3rd of 2026 because you did not appear.
For a payment review, right?
I don't know what it was for. It says failure to appear. So let me just go through this in just one moment here. In 2025, sir, January of 2025, you have a conviction out of this court for disorderly conduct. All right, that was the charge. And you pled to disorderly conduct. And what was your sentence out of this court, sir? Did you have fines and costs or were you on probation?
Fines and costs, man.
Okay. Then, sir, you have in September out of the city V course, you have another disorderly conduct.
That was disturbing the peace now.
Disorderly conduct, disturbing the peace. They're used actually disorderly hyphen disturbing the peace is what it's showing in the 25th District Court.
I'm looking at the PSI. I don't see that, but I'm not.
Yes, it is. It's on the first page under criminal history.
On the third page,
First page on the first page of the PSI under criminal history.
I see, fail to obey. And 03.
Yes, go to the last one, 2025. That's Lincoln Park, disorderly hyphen disturbing the
936.
Right.
Right. Like that I see. But I also, I do
Did you
not
get
see.
the amended one? There was an amended one that was done that showed the wind out one.
No, I don't.
Okay, that was January 23rd. So what I see, sir, is this. This paints a picture for me. A picture of somebody that is continuing to be unable to control his emotions. You have a disorderly conduct in Wyandotte. Then you get one in the city of Ecorse, which is within the 25th District Court in Lincoln Park. That's why it's showing Lincoln Park. Then that's around the same time as you got the one in Lincoln Park. In fact, right before that is when Mr. Mazguy was victimized by you, sir. So what I see, sir, is an individual with escalating emotions that doesn't know how to control their emotions. That's what I see. You had zero reason to pull over. Zero. No reason to pull over whatsoever. And then not only did you pull over, you get out of your car and then you start walking up to Mr. Cunningham or to the area, wherever you intended to go. You put your hands on an individual with such force, sir, that he fell backwards, fractured his wrist, did something to his elbow, and was knocked unconscious. With one time that you touched him with such force. That was what happened as a result of your actions. You could be mad that he pulled out in front of you, he turned in front of you, whatever it is, sir. You have the right to be angry about that, frustrated, whatever it is. You don't have the right to act upon that anger in the manner in which you acted. None. Counsel, I asked for the recommendation.
I've indicated, Your Honor, the amount of restitution requested still doesn't show any out-of-pocket expenses to Mr. Cunningham. As such, until that is shown, restitution, I mean, who gets the restitution? Is my question. Is this a bill from the hospital?
It's a bill from his insurance. It's a statement from his insurance company that they did not cover that. So here's my question, counsel. If Mr. Mazguy doesn't have that money to pay out of pocket and he has to pay as he gets it from your client, I'm sorry, Mr. Cunningham, if he doesn't have the money to pay out of pocket and that one lump sum, then your proof of payment is not going to be there at all. So perhaps, and I don't know, maybe Mr. Cunningham has to wait until he's paid restitution by your client before he can pay that bill in full. I have no idea.
I understand that, Your Honor. This doesn't, and I just saw this, when it's attached. This appears to be claim was put into the hospital, and according to Mr. Mazdai's testimony, this is rejecting the claim. It's not
Mr. Cunningham's.
Mr. Cunningham.
Yes.
I don't see where this document says that.
All right. So what I'm going to I'm going to direct Mr. Cunningham to just get something from his insurance company indicating that he is the one that's responsible for that balance. There you go.
Yeah, once we get that, we can figure out the exact amount.
Great. All right. Anything else?
Other than that, Your Honor, Mr. Mazda has indicated that we're asking the recommendation be adopted.
Here's what this court's going to do. This court has serious concerns regarding Mr. Mazguy and the safety of this community, any community, quite frankly, because Mr. Mazguy, as he's even indicated, doesn't even know Mr. Cunningham, yet behaved in this incredulous behavior with somebody he didn't even know, with his 4-year-old daughter in the car. And it's also clear to this court that Mr. Mazguy's behaviors continue to escalate. And so Mr. Mazguy definitely needs some assistance in managing that anger. The court's going to note, after hearing from Mr. Mazguy, Mr. Goldpaw, Mr. Cunningham, that in review of the report, the recommendation, the police report, the criminal history of Mr. Mazguy, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Mazguy. The court's going to order 180 days jail. The court's going to suspend 150. That means you're going to serve 30 days jail. The court's going to also indicate that upon your release from jail, you're going to be sentenced to 24 months probation. You're eligible for early discharge with a hearing. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to have any contact with the complaining witness in this matter, Mr. Cunningham or Ms. Hillier. I'm also going to include Ms. Hagerman, as she was in the vehicle as well. That's phone contact, text message, email, social media, third party, anything of the like. You're not to go to any of their homes or places of employment. You're not to possess any weapons or firearms. Do you have any of those, sir? I can't hear you.
No.
You are to participate in a 12-week anger management class. The rehabilitative goal for that condition is so you can further have an understanding and some tools whereby you learn how to properly manage your emotions when you are in an upsetting situation. And then the court's going to order mandatory jail for any violations. Sir, you're looking at your charge, your conviction is for up to 1 year in jail. All right. I have now sentenced you to 180 days in jail. That's half of that term at this point. And you serve 30 of those days. No. This behavior is not tolerated at all.
Yeah. Can I ask a question?
What's that?
Can I have a little time so I can get this unemployment, a couple more checks for the van? Because I mean, I take care of the household. I'm at a household. So can I have a date to turn myself in for the 30 days, ma'am?
So, sir, here's the thing, right? I'm not giving you a couple weeks. So it's not going to be a couple more paychecks. And if you're set to go back in April, that's next month, right?
Yeah, because I'm on GPS chat. That's why I asked, ma'am. I'm still on tether.
I understand that.
So
but sir, this 30 days is part of your punishment for the behavior.
Right away, you give him 1 week?
No, not give him 1 week. The most I will give him is till Friday. That's it. March 27th.
And he will go to Wayne County Jail?
Yes, you're going to go over to probation. You're going to get all of your next steps as how you go and report to from jail, sir. As it fines and costs, the court's going to order a $1,000 fine per statute. It's up to $1,000, $100 screening assessment fee, $1,200 supervision oversight fee. That's 24 months at 50 months. I'm sorry, at $50 per month. If you are discharged early for probation, sir, then up to half of that, or then the part that you're not on probation anymore, sir, that portion would be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. The court's going to order $3,427 in restitution upon the proof that Mr. Cunningham is responsible for that. So that's $2,725, then plus the restitution portion that brings it to $6,100, approximately $6,152. You can set up that payment plan upon your release and return to work. Keep your hands out of your pockets, sir, please. Any questions?
Thank you.
That did indicate you're eligible to request early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation reports have been completed. You've had at least all probation conditions have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Given that this is a large amount, sir, you just have to make sure making your payments monthly and timely and so forth.
Thank you.
Have a good day. So let's go on the record in the matter of the city of Wyandotte versus the Lawrence Bartoloni, 251674A. Counsel, your appearance, please.
Your Honor, good afternoon. Richard T. Serrano, P. 33828. Your Honor, today I appear with MIDC counsel on behalf of confined presently in custody in Wayne County Jail. And I appear today at the time for sentencing, Your Honor. Please state your name, sir.
Lawrence Attilio Bartoloni.
Okay, very good. Thank you. And sir, I do appreciate your patience today. Your attorney has had a significant number of cases that were a little bit more complex than what is typical. And then I had a meeting at 1 o'clock that I couldn't move because that person had a meeting at 2 o'clock afterwards. So I do appreciate your patience today, sir.
No problem, Your Honor.
That's all. Today's date scheduled for sentencing on your client's plea to operating while visibly impaired. And we had adjourned it because your client, I don't know what happened with that thing now. Can you turn it down again, sir?
Turn it down again? Okay.
Yes.
Is that good?
I don't know. Is that?
Because I can barely hear you now.
Well, I'm trying to not have it reverberate because if your volume is up higher, then it's difficult to hear. Then there's all that feedback or whatever it's called. So your client was set to be sentenced February 9th. Your client we did not conduct the sentencing on that day because your client was interested in treatment court. Further, your client said that he had a pending OWI case in either the 25th or the 28th district court.
It was Southgate, 28.
Okay. Well, doesn't seem to have it there. I don't know what's going on over there because it doesn't seem to be there. But then he says that he's a victim in a case at 28th district court. So I don't know. All I know is that Ms. Shine had sent over the paperwork for Mr. Bartoloni to the treatment court, to 25th District Court, yet they've claimed that they didn't receive any of it. So, that's where we're at.
Well, may I put him to the question if he wants treatment court, Your Honor, at this point?
Yes.
Mr. Bartoloni, do you want to engage in treatment court in another court to take care
Wait,
of?
I can't hear nothing.
Oh,
Okay, sir, then I guess turn it up, but then I don't know if you're gonna be able to hear it with all the reverberation from the cinder block.
I know I can hear the verbiation too. Is that better?
Well,
Okay.
so far it's okay.
did you hear what I said, Mr. Bartoloni?
No, I didn't.
Okay. Are you interested in a treatment court through another court? It's an intensive program to help you cope with any problems you may have concerning alcohol or drugs. Or do you want to remain and be sentenced today as a non-treatment court client?
No, I can go to treatment court. I understand.
Okay, so then counsel, what we're going to do is I'm going to convert your client's bond to a personal bond, have him released with the tether, and we have to resend it to the 25th District Court because they didn't get it to be able to interview your client.
Will he still be in custody, Your Honor?
No, I just said I'm going to convert it to a personal bond,
Oh, okay.
and then he still has to have the alcohol tether though. All right.
He tells me, if it's accurate, he tells me he's been in custody for 5 months for this matter alone.
Well, let's see here. No, well, December 8th, January, February, March, 3 months.
I don't know. They all go. Did you tell me 5 months, Mr. Bartoloni?
Pardon me?
Didn't you tell me 5 months you were in custody?
I got in there before my birthday, and that was in December.
Okay, well, it's not.
December
5 months,
16th.
All right. Well, you're going to be in good hands in treatment court, so we'll get another date then, Your Honor.
Yes. All right. So, sir, I'm going to convert your bond to be a personal bond. All right. Because you've not been able to post your bond, and that there is some sort of administrative mix-up by the 25th District Court because the referral was sent February 10th. So, sir, we're converting it to a personal bond, $7,500 personal bond, and then you just have to have the alcohol tether before you're released. Okay, so you'll get the
Okay.
alcohol tether, and then you can be released.
Okay, I get you.
You hear all that? Okay, very good. We'll see
Yeah.
you back short. We'll see you back. You'll get notification of a new date, sir.
Thank you. Your Honor.
Okay,
Thank you. Have a good day.
thank you. You too.
Does the court need you to do anything with any of the people in the back of the own?
I don't know. I'm just doing as I'm told. I don't know.
No.
Okay, let's go off the record for a moment.
See you Wednesday. Thank you.
You're welcome, Mr. Serrano. Thank you for your day today. Okay, this is the matter of the city of Wyandotte versus Robert Jenkins, 26388 A and B.
Good afternoon, Your Honor. Your Honor, John Bolt, P. 30758 on behalf of Mr. Jenkins. Mr. Jenkins, please put your name on the record.
Patrick Jenkins.
All right, did that come through, Autumn?
Yeah.
Okay, very good. Thank you.
Your Honor, as to the time,
Okay, good afternoon. Okay,
I'm sorry,
no, it's okay.
as to the time, I extend you to charges, waiver for meaning of those charges as the.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial April 8th at 10 a.m. All right, Mr. Jenkins.
Yep.
I'm sorry, I'm writing Mr. Jenkins. Mr. Goldpaw has to bond.
Your Honor, Mr. Jenkins is 35 years old. He is single. He lives with his father on French Road in Detroit, where he helps take care of his father. He's also gainfully employed, has been for the last 2 years at the Green Dot restaurant in Detroit. You got great sliders.
We got Stables? Yes.
Stables, Your Honor. He has no prior criminal record. We're asking for a personal bond in this particular matter.
Okay, Mr. Jenkins, you help take care of your dad. Okay, is he disabled?
Yes, he had, he can never work. He had got injured at Walmart and he had to have surgery on the back of his neck.
Okay,
So
I
just helped
understand
him out.
that, but so, okay. Have you ever failed to appear in court for any reason, sir?
No,
Currently on probation or parole anywhere?
no probation.
Are you out on bond in any other jurisdiction?
No, ma'am.
If you were to test right now, sir, what's in your system?
Only marijuana, ma'am.
Marijuana.
Marijuana.
Okay. Do you have a valid prescription for that, sir?
No, ma'am.
All right. So when's the last time you used marijuana, sir?
When I got off of work last night, ma'am.
Okay. So all right. So moving forward, sir, you're not to possess or consume any alcohol or drugs that are not prescribed.
Yes, ma'am.
You don't have a medical marijuana card, do you?
I'm sorry.
Yeah, that means marijuana as well. Understand that. You're not allowed to use marijuana without a medical marijuana card from your primary physician. Do you understand that?
Yes, sir.
Okay, just wanted to make sure that, right?
Okay. And so, the court's going to note, based upon the nature of the charges in this matter, and that the court's going to order a $2,500 10% bond. And you're not to possess or consume any alcohol or drugs that are not prescribed. All right, sir. So you got a copy of your bond conditions, and then we'll see you back on April 8th.
Thank you very much, Ron.
Thank you.
Only two more. I'm so very sorry about that. Is there more than two? No, just one of them. Okay. All right. We're on the record of the matter of the city of Wyandotte versus Dennis Arquette, 231551A. Well, good afternoon. Counsel, your appearance, please.
Your Honor, John Goldpaw, P 3075 on behalf of Mr. Arquette. Mr. Arquette, please put your name on the record.
My name's Dennis Arquette.
All right. Well, you're in custody. There's a warrant for your arrest because you failed to appear for sentencing on November 1st, and you appeared to not have walked in voluntarily. So, counsel, the court will the warrant's recalled, and we'll have to reschedule this for sentencing because I'm not sentencing somebody that's been 2 years.
I understand.
Information. So, I presume I should just pick a day. Well, their probation, I don't know. They'll have to pick their date. I don't know their schedule. Okay, as to bond.
As to bond, Your Honor, as the court indicated, this is he was picked up in an automobile last night. In fact, he was picked up at the same time that Mr. His name was Nelson. We just arraigned. They are roommates, as he indicated. He lives roommate. I just learned that.
Wait a minute. The one with the 3 cases from 2018 that we're talking? No.
The 2 cases.
Oh.
20.
Kaczynski.
Yes.
Okay.
Yes. Your Honor, he is presently, he's You're not working now. You're unemployed. Is that correct? You're going to,
I'm disabled.
you're disabled. Your Honor, when we reviewed the matter, he indicated that he had no excuse. He just felt with the sentencing. He completed and complied with all of it appears reviewing the docket entries that he had his PSI interview, and that was forwarded to an attorney. It appears, at least according to that, the reason he is here was his abilities just basically didn't do it. That's all I can tell you. Is that correct, sir?
I didn't think it was. He didn't have a seatbelt on, so they said, "You want to give me a ticket?" for
No,
that, I
sir.
guess.
No. We're not talking about, no. Why you didn't show up at your sentencing back in September of 2023.
I moved and I didn't get the forward. I didn't get it. I spent 2 months in Wayne County Jail in
Fine.
June of 2023, and they said that would
Pause.
cover. The judge said that.
Sir, you moved from the Almar Motel, correct?
Right.
Okay, so then did you notify anybody? Did you change your address with the post office, with the Secretary of State? Did you notify anybody of your new address?
Oh, I spent 2 months in Wayne County Jail, and the judge in Southgate said, "Oh, they want you in Wyandotte, so you spend 17 more days in Wayne County Jail, and that would take care of Wyandotte." The way I understood it.
Well, sir, I can tell you that another judge isn't sentencing somebody in my court. That's not how that works. So
She said Wyandotte, and just assumed it. And I was there 2 months, so for misdemeanor.
we're there for something else. And then after you got out of Wayne County Jail in August is when you picked up this case. So this shows June 20, you were in this court August 29th to 23 for your arraignment. So you were out of custody at that point, sir.
I was in court here.
Yes, sir. In 2023, when this offense occurred, you were in court. That's how I knew you lived at the Almar Motel, sir. I didn't just.
I haven't lived there in several years.
At the Almar Motel?
Yeah, I lived down there in 2023.
I have that.
Okay.
I have his new correct address.
Let's all pick it up.
Well, sir, just so you're aware, you signed the advice of rights form August 29th to 23, and then you indicated homeless. But then on the record, you indicated Almar Motel. That's why I wrote that down. So otherwise, I wouldn't have known where you were staying, sir. Sir, how are you in custody?
Your Honor, he was in the vehicle that was stopped. Mr. Brzezinski was the driver of that vehicle. And he was questioned. He talked to the officers, and they ran both individuals, found that warrants were outstanding.
All right. And so, sir, do you have warrants anywhere else?
No.
Are you out on bond in any other jurisdiction?
No.
And if you're to test right now, sir, what's in your system?
Nothing I know of. Trying to think I haven't. I smoked some marijuana. Yeah, probably.
Okay. And do you have a valid prescription for marijuana?
No.
Okay. All right, based upon your previous failure to appear and the multiple locations that you have resided at, the court's going to enter a bond of $5,000, 10% bond.
I promise I will show up for court. I did not know I had a court date. I will make it there. No reason to keep me in jail anymore. I will be there, I promise.
Sir, you had you had 2.5 years to still come into court or to contact the court to see if there was anything still pending. You did nothing. So that's the order of the court.
No, I thought I spent my time in jail and it was taken care of. I really had.
That was with the 28th District Court, sir. So if you're unsure, then you contact the court. You did not do that. We'll see you back April 8th.
I was taken care of.
We're all done, sir. We're all done. We're on the record in the matter of the city of Wyandotte versus Evelyn Cook. Off the record. Yes.
I thought you were going to.
No. Oh, no. I'm sorry. No, I did not say, if I said April 8th, I'm incorrect. That's going to probation for a new date.
That's correct.
Yes, that's my fault.
Thank you.
Thank you. All right. And we are on the record in the matter of the city of Wyandotte versus Evelyn Cook, 26390.
Correct.
All right. And counsel, your appearance, please.
John Goldwalk, P 30758. Ms. Cook, would you please put your name on the record?
My name is Evelyn Cook.
All right. And so we are going to conduct the arraignment, counsel, since your client's in custody, as to the arraignment.
Thank you, Ryan. You're right. That's not guilty. Standing to the charges, waiver of fault, and ask for a plea of not.
All right, the court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment.
Gotcha.
Schedule this matter for pre-trial, April 8th, 10:15 a.m. It's to bond counsel.
That's the bond, Your Honor. Ms. Cook is 58 years old. She is present on probation out of the Third Circuit Court. She is gainfully employed as a home care nurse. She is single and she lives with Mr. John Bartola. My understanding in reviewing the report is that the police arrived and because of quote suspicious activity, according to the report, and that Miss Cook met them at the front door and handed over a bag of suspected narcotics. She also explained to them what was going on, and they did an investigation, subsequently arrested her, and she's been in custody since 26.
I thought your client looked familiar. She was just here a couple months ago. Well, 4 to be exact.
Yeah, it was a while ago because I'm sure that she's on probation, as I've indicated.
Right, for felony
Attempted possession, I believe.
No, she had felony matters. No, it pled guilty. Oh yeah, to attempt felony controlled possession.
Right.
Also, she had another felony possession charge dismissed.
That was out of the same case.
No, it wasn't. That was from Flat Rock. In 2023 that she didn't take care of until apparently she was in custody on the Wyandotte case. And then she also has a bench warrant out of the 33rd District Court for larceny.
You know, I also noted, Your Honor, just for these purposes, noticed that there was a request. It is for the purpose of bond condition. We're asking for a personal bond in this particular matter, but one which she can reasonably make, so she can continue her probationary status with the Third Circuit. I also note in the file, this matter was sent down to the Wayne County Prosecutor's Office, and they denied the warrant, stating insufficient evidence to prove beyond a reasonable doubt. I each person can, address each issue. I'm only bringing that to the court's attention because looking at what is in the report, this wasn't, it was unusual when I read it. And so therefore, I'm asking for a personal bond to run whatever bond conditions are and so this matter can be addressed.
Why does the name John Bartolotta sound so familiar? Does he have a case here?
I do not know your
He's disabled, Your Honor.
What is that?
He's disabled. He's handicapped. I take care of him. He was on 571 St. John Street.
Oh, yeah, we know that. Don't worry about that.
Right.
Ma'am, if you're in a test right now, what's in your system?
With nothing. I don't do nothing. I don't have a prescription for nothing. And I have my daughter is a doctor and a surgeon, and I was told by an X-ray and MRI that I had a brain aneurysm on the right side of my brain.
Okay, so would that cause you to test positive for something?
No, it's just, no, ma'am. I was just saying that's something that's wrong with me. I don't have.
Okay.
I take blood pressure pills.
Well, given the fact that your client has multiple warrants out for arrest, ma'am, and also who's Mr. Let me see here, Mr. Adam, maybe?
Hannon.
Who?
Hannon.
No.
Oh, I saw that.
Who's Anthony Tatmer?
That's my ex, and I did not. It's about a case of PayPal something.
I'm just showing that there's an injunctive order, so you're out on bond on something, right?
Yes, I am from Trenton.
Okay, what case is that, ma'am?
Larceny, I think it is.
Oh, that's the one you have a warrant out for your arrest. Given the number of matters that you failed to appear for, this court is going to order, and the fact that you're currently on probation, this court's going to order a $5,000 10% bond. In the event you post bond, you are not to possess or consume any alcohol or drugs unless prescribed.
Yes.
Have a good day.
Thank you. All
right, thank you. All right.
I don't get it. I don't understand. How did I even do that? I will. Oh, I'm doing that thing. I will research it later. My goodness, ladies and gentlemen. We started the night off with Judge Mogan. She had a long little diatribe. Then we moved on to Judge DeSanto and let her do what she does best. Man, we had some interesting ones in court today, didn't we? And here's the kicker. That wasn't even the best of the day. That was just some really good ones that I found that I thought that you might not have seen. But stay tuned in, ladies and gentlemen. Saturday's going to be a very interesting day. We had some soft sits in court today, all over the place. We'll be seeing at least one or two. And I don't know what else to say. Ladies and gentlemen, chat has been off the chain tonight. Becky, Rhonda, Rometicus, Candace, Kiernoth, Julie, Mama, X25, oh boy, wherever you are out there, Steven, people whose names are coming up on the screen as I'm speaking. One brick, one home brick. Matt, I know how to say your name. Thank you, everybody. Thank you, everybody, for hanging out with me tonight. I greatly appreciate it. I will be doing this again tomorrow night. If you're not familiar, we do this every single night of the week. Same old time, same old channel. That's 8 p.m. Central, 9 p.m. Eastern. And I'll have a bunch more cases from the day. We'll watch. And then we'll watch all of the cutting room floor material on the weekend, through the course of the week. I have independent little snippets, little individual cases and case compilations that come out at 4 a.m. every day and noon. That's Central Standard Time, so whatever that is in your time zone, whatever. So keep an eye out for those. Comment, like. Hope you enjoy all of it. That really doesn't help. P. Nebrit. P. Nebrit? I think that's right. P. Nebrit. Or is it Nebrit? No, it would be a hard, like, Nebrit, right? Am I close? Am I smelling coke? No, I am not smelling coke. Not right. Not right. Give it about 30 minutes. Maybe if we're lucky. Thank you so very much for your donations tonight, Kirnoff, Zelda P the OG, and Wixom Heroes All. Thank you so very much. For now, I will say I am your lone wolf Usul, and I am tired. And I am out. Is there anybody still here? Have you stuck in that long? You know, right? Well, our final little piece of wisdom for the night is, have you ever noticed that anyone driving slower than you is an idiot, and anyone driving faster than you is a freaking maniac? I felt that was poignant. Have a good night.